fertile area if you don't have to. My answer would be short.
Yeah, no, I figured, but why not? So, good evening. This is Media Reporter, and I'm Howard Homonoff. Thank you for joining us. And I'm here with part 2 of our interview with Randy Milch, who is the Executive Vice President for Public Policy and General Counsel for Verizon Communications. Randy, thank you for coming back.
It's a pleasure to be back, Howard.
So we appreciate you've now doubled your all-time record of appearances with me on this program. So I know that'll be tough to beat.
I'm going to put that up in my record book.
So it's sort of like the Saturday Night Live host club, you know. So you're the Media Reporter guest club.
Okay.
You can be a part of. So last time we focused on kind of Verizon and today and what it is and kind of how it's gotten to where it is. I want to sort of shift gears to the public policy hat that you wear and some of your sort of both process and particularly the substance around some of the big issues. First, because I know it's in the news now, just last week it was announced that Tom Wheeler is going to become the new head of the FCC, replacing Julius Genachowski. I don't know if you know Tom and Tom Wheeler and have any thoughts about sort of his background and his potentially upcoming tenure.
I do have the pleasure of knowing Tom. He's a distinguished veteran of telecommunications from every which way, and I think that we look forward to working with him once when he's confirmed for the post. We're also, by the way, very happy and proud of Mignon Clyburn, who is the acting chair now of the FCC, or soon to be acting chair, I should say. She's been named to be acting chair as soon as Chairman Genachowski formally exits, and it's a pleasure to work with her in that role as well. But Tom is one of those distinguished folks who you're always proud when they go into public service. You think it's a great thing that they would spend the time and take the energy and to do something like that. So my hat's off to him for being willing to enter into public service and try to make things better.
Great. We've operated under this Communications Act of 1934 since 1934.
Thereabouts,
interestingly
yes.
enough, with many changes along the way, but kind of take a step back and you are, I've known to be occasionally somewhat opinionated about the regulatory world that we operate in. Give us a sense of sort of how effective, in a sense, is the regime, and I don't mean the people, I mean sort of the structure that governs communications law under the Communications Act. Is it time to revisit the whole thing in some comprehensive sense? Are there tweaks to be made? Give us a kind of overview from your stance of that communications regulatory framework.
It's a great question, and it is the subject of a lot of mental exertion on a lot of people to think about this. You point out that we've been under the 1934 Act since about 1934, but I think it's important to recognize that the 1934 Act is not very far removed from the Commerce Act of 1910 and not very far removed from railroad regulation at the end of the previous century. So the DNA of the regulatory regime we have today is over a century old, and I think anyone who has lived through the utterly startling revolution in how we communicate over the last decade and a half has to recognize that the regime that's in place is just simply not commensurate with the facts on the ground. So it can be tackled in a number of ways. The issues can be sort of defined in a number of ways. I think that it's critical to understand that first and foremost, you have a regime that concentrates on simply a few of the players in an ecosystem. And it's a regime that disproportionately then seeks to regulate, because that's the only place it can regulate, and that is the tendency of regulators, on Verizon or on AT&T or on Comcast or one of the other carriers under the various regimes, but leaves out the rest of the story, as someone once said. The folks, the businesses that have influence on the way people communicate today, and significant influences. The largest global carrier is Microsoft because they bought Skype. Certainly, there are very few people who go on the internet who don't somehow run into Google and the effect that Google has on the experience that an end user has. And this is not a plea to regulate those entities. This is a pointing out that regulation that falls solely on some of the players and not on others inevitably skews the way that businesses invest. It skews the way that that consumers receive services, and a level playing field is the right way to approach this, in our opinion. I'm glad you separated out, by the way, the regime from the people, because I don't want to suggest that the folks who are left to try to operate as regulators in a regime like this have an easy job. I don't think they have an easy job. I respect the dedication with which they approach it. I do think, however, they are naturally inclined and appropriately inclined, given their mandates, to try to assert jurisdiction where we don't believe they have jurisdiction under the laws that Congress has passed. And the FCC, like many other entities, is a creature of Congress and it has no jurisdiction beyond that which Congress gave it. I think that it's important that at some point we arrive at a new regulatory regime. Is now the right time? I'm not quite sure now the right time. Now is the right time, given the notable issues that are in front of Congress at the moment. Comprehensive reform of the '96 Act is as you as a veteran of Capitol Hill would know, would be a hugely time-consuming and energy-consuming process. And with the fiscal issues that are in front of Congress and the need for tax reform that's in front of Congress, this might not be the right time to raise those issues, if you were thinking that it was going to get done. Right. But it is a very important point for us.
Specifically on the '96 Telecom Act, and it's interesting because now we're nearly 20 years past that. I used to work for Ed Markey. Who
Don't
was
make me feel old, Howard.
Sorry, one of the. I know. I was 17. I was really. It's amazing the work that I was doing at that age.
You were a prodigy.
Yeah, I was, and you were 15, I think, at the time. So it's incredible. But we're now stepping back and looking at the '96 Telecom Act, which was certainly passed under the with the idea of promoting telecommunications, both wireline and wireless. It was passed at a time when the internet, for most people barely existed, and if they were, on the cutting edge, they might have AOL accounts, but that was about it.
With dial-up service.
With dial-up service at 14.4, et cetera. But the '96 Act, did it, obviously much has changed, but has it been effective in what it was supposed to do to you? Is there... it's now obviously a part of a whole regime, as you point out. It's been around for decades. But was it the right notion in '96? Was it what's happened since?
I think it was having lived through it, having lived through the implementation of it, I think it was a spectacular success. I don't think that if you look at the investment that has happened in telecommunications in this country since the '96 Act, and since in particular the series of legal cases that happened in the beginning of the 2000s, which reformed the FCC regulations to what the '96 Act was actually meant to do, you will have seen a level of investment here in the United States that is unsurpassed anywhere in the world. And the reason that it happened is because the '96 Act embraced a light or no regulatory regime and deregulated so much of this sector. And from that deregulation sprang the spectacular investment in the internet, spectacular investment in wireless services, spectacular investment in fiber. and increasing bandwidth to people's homes and their personal devices, and saw the birth of Google and and Facebook and the various. There's no mystery about why all those things were created in the United States. They were created in the United States because of the energy and investment that was put into the platforms on which those services ride. So the 96 Act, in my opinion, was a spectacular success. And the investment that deregulation encouraged has stood this country in great stead. It is why there was a continuing bright spots in the economy during the downturn after 2008. It was because we had that investment. And if you look at the investment that happened in places like Europe, particularly in Europe, where the regulatory regime was one that mandated forced sharing, there's not been that investment. The level of capacity on wireless services, for instance, there is far lower than here. Fewer than 3% of folks in Europe are on 4G services. Much higher here in the United States. 50% of the data in Verizon Wireless is already on 4G LTE. So I think that it was a spectacular success.
So you don't see the point that, or an argument that, well, if government had done nothing, inevitably somehow this investment would have flowed, and we would have seen the innovation anyway, because business would have innovated in any case.
No, I don't think so. I think in fact we have the alternative case. Yeah. The alternative case is in Europe right now. Yeah. And so I think that there's a lot of ersatz competition in Europe. There's a lot of forced sharing. There's a lot of competition, quote unquote, at the retail end of the market, but there's not a lot of broadband deployment, and particularly on the wireless side, it's really suffered.
How about you often hear sometimes the complaint that the U.S. we're behind many other countries in broadband. Is it true? Is it something that we should be doing something about from a policy perspective, or are we looking at the wrong, or do we have our eye on the wrong, ball in a sense?
I don't think it's true. I think that you have to make apples to apples comparisons here. So when you look at countries that are vastly smaller than the United States, and you look at countries where there's a very significant concentration of the population in just a few urban areas, you find it much easier to come up with impressive numbers about broadband availability simply because when you do the math, you're not making an apples to apples comparison. If you look at the United States, the availability of broadband wireless service from multiple carriers is upwards over 90% of the population. The availability of broadband, as the FCC now defines it, with a rather healthy 4 megabit type of service from multiple carriers on the wired side, extends to upwards of 90% of the population. So I think that the truth of the matter is we have a huge country. We have a lot of rural areas in this country. We need to make the efforts to connect those rural areas, and Verizon is doing that particularly with its Verizon Wireless 4G services, 4G LTE services. Verizon Wireless is the largest rural wireless carrier in the country, and we don't get advertised that way because we cover so much of the entire country. But we are the largest, and we have taken efforts with for instance, our Rural Partners program on the LTE side to provide rural wireless carriers with our spectrum. We lease them our spectrum. We provide them the backbone. We provide them with the infrastructure to build out 4G LTE in rural areas. We now have 19 of these rural carriers that we're affiliated with. I was just at our annual meeting out in Tulsa, Oklahoma, and had the pleasure to sit with a guy named Rick Rule, who was not the former antitrust chief, but a different Rick Rule.
It's an interesting spot to meet that Rick Rule.
Who is the general manager of a cooperative telephone company out in western Oklahoma and Kansas, who is one of our LTE partners, and they're going gangbusters. They've been doing it for just over a year, and they are very proud to bring LTE service out to their rural customers, and it's a great way to connect rural America in a very efficient fashion for many of the, not all of their needs, but for many of their needs. So I think that we have capabilities here in the country to do this, to connect the rest of the country. I think the bigger issues are ones of adoption, much more than they are of the presence of facility, the access aspect of it. We clearly have adoption issues. There are many communities where there's a shortage of computers. There are economic issues associated with that, and I think that adoption and training are really key areas that people ought to focus on, as opposed to some sort of mandated build strategy. We have no objection to, there's a universal service fund. We were very supportive of sort of altering the trajectory of the universal service fund toward broadband issues. We think that's an important thing to do, and we're happy to have folks partake of those funds. We're supportive of municipal networks. If municipalities want to put together networks, Verizon's not, sometimes we get tarred with the brush that we're against that. We're not against that. So I think that there is plenty of need to go around, and plenty of opportunity and facilities to go around as well. So I think matching them up is more of an issue than sort of throwing up your hands and thinking that we have somehow failed in our deployment efforts in this huge country that we have.
I want to shift gears a little bit. We've been talking about your role as providing the network, whether it's wireless or wireline. Talk a little bit about your role in the content business. And Verizon is, in terms of multi-channel video, one of the top handful of providers in the country now through its Fios TV service. And I remember a number of years ago, Sumner Redstone, who is still the chairman CEO of Viacom, who coined the phrase "content is king." And for years we've sort of heard this debate of content versus conduit, and Verizon certainly would be seen as a conduit as opposed to the content player. But is content something that you feel like you need to be more involved in, more as an owner creator in the emerging digital world? Are you happy with where you are with respect to content delivery? Content is also complicated. It might be king, but it's also complicated. Yeah. By the way, there is also the school of thought that says content is king, but distribution is God. So that's, you can throw that one around. Okay, good. I'll use that. So to sort of break down your question, I don't think that at this moment we feel as though that we have a need to actually own the content. The content world is changing rapidly. There is a highly complicated business and regulatory structure that surrounds the way content goes out to American people, and I don't think that many folks realize how complicated it is and how many interests there are that are very deeply embedded, both through regulation like the must-carry rules and the retrans consent rules and the distant station rules. I mean, these are rules that were put in place a long time ago. They do not fit the internet era. They do not fit the amount of self-generated content that is flowing across the internet and flowing across people's networks. And they do not fit emerging technological issues like the Aereo service, like over-the-top services, other over-the-top services. And so I think that this is an overall regime, and by that I mean an overall business model and an overall regulatory model that is, in my opinion, far more volatile than I think most people realize. And by that I mean it's a business and regulatory model that is so out of sync with the way content is actually used and produced and transmitted and dealt with that it's going to have to change, because the real world is outstripping these models. We feel like we're deeply involved in content because, as you say, we're one of the largest multi-channel video providers through Fios, and
we have seen content costs continually rise. We have tried to take steps to ameliorate those issues for our customers. We dealt with the issue of regional sports networks and the significant extra costs those bring with them by on the one hand imposing a fee, a regional sports network fee, but on the other hand providing services that didn't have the regional sports in it, so that if you didn't want to pay the fee, you could take a whole different tier of service from us that avoided those issues. Because we felt like if we were going to put a fee on for those who used it, we also ought to provide an alternative to people who didn't partake of the sports to that degree. We have discussed at various times the questions of whether there will be a la carte services. That's all bound up in the sort of the contractual obligations that you know so well between content providers and the video providers. Whether there would be the possibility of our payment being actually linked to how many people watch a service, which would be different, because right now it's linked to how many subscribers you have, not whether those people actually watch a channel, and which we think is a fair way of approaching this issue in some respects. So there are the retrans issues that come up, whether in fact what kind of fees we have to pay the broadcasters for the retransmission of their content over wired services, over cable services, and all these come together in sort of a mishmash, which I think that the general public sees only at the end of a contract period, when there's the traditional battle between the content provider and the distribution provider about who's at fault for the potential of the tennis network going dark, right? And certain people get very exercised, and the rest of the people sort of go, I don't care. So in the midst of that, you've mentioned the Aereo decision, the Second Circuit case, and for those who aren't familiar with it, maybe you can give a bit of an explanation of what happened there. But Aereo, how concerned are you as a multi-channel video provider? You're not the content owner, you don't own a broadcast network, but you transmit them to your subscribers. How concerned are you by the decision, by the fact that it's coming out of a court as opposed to through a legislative process? How are you viewing what's going on there? So the Aereo decision, basically was in many respects a preliminary decision, because it's really about whether there should be an injunction or not. Right. Concerned a service that has been created, which essentially takes broadcast signals off the air through individual antenna, that is one antenna per Aereo subscriber, and basically puts that content off of that individual antenna onto the internet to a subscriber, so that the Aereo subscriber gets the broadcast content over the top. That is, if they have an internet connection and they're an Aereo subscriber, it comes to them via Aereo, right? And there's a DVR capability and the like. And there was a decision not to enjoin that service. Certainly the content providers, the broadcasters, felt as though this was inconsistent with their copyright and inconsistent with their rights in the content to have it taken off the internet, taken off the air, put on the internet, and delivered to homeowners or subscribers. The district court refused to enjoin it, and the Second Circuit, in a 2-to-1 decision, agreed with that decision, not to enjoin the service. Personally, I know this decision very much disturbs the content providers. I can understand why that's the case. There was at least at this point, a contrary decision coming out of a district court in the Ninth Circuit. So I think that we're set up to see that there's going to be a conflict between potentially a conflict between the circuits, which could end up at the Supreme Court, which is all very interesting. I think that Verizon is not itself doesn't view itself as threatened by the Aereo decision. I can understand that many of our content partners feel threatened by the decision, so I'm appreciative of their concern over it. If I were to put more of an intellectual academic hat on about the thing, I think it just shows up the fact that this is an issue that needs to be resolved. I saw today that there were there was a news article that Tom Britt, who's the head of Time Warner Cable, Glenn Britt, I'm sorry, I apologize, Glenn Britt. He was quoted as suggesting that Aereo might be an interesting way to go for Time Warner Cable, which immediately got the predictable reaction from some of the content providers who deal with Time Warner Cable. So, listen, I'm not going to opine one way or the other on the issue. I think that though it is a significant issue for the sort of the edifice of content that is built up, and may break open, may result in a significant change in the way the whole infrastructure occurs. I'm sure the content providers firmly believe they're going to win this decision eventually, one way or the other. So we'll see what happens.
Does it suggest, or what do you think, maybe the odds that this drives Congress to get involved, or the FCC to step in and say there's something whether it's by the pressure from the content community to take some step? Well, we can't just leave this to the court. Do you see that happening? Is that realistic in Washington today?
Well, I think that there had been a push to legislatively reopen some of these regulatory structures that Congress put in place that concern retrans and the like. And I think that if it were to open up the door, I think it would open the door to a wholesale rethinking of the regulatory structure, which may be a good thing on this front. From surely the perspective of making it G up with the way the world works today.
Right. We're winding down towards our session here. I want to kind of bring us back a little bit to where we started.
Okay.
All right, and your career and kind of looking back on things and looking ahead. Give some advice, if you can, sort of the perspective of people who may be watching, and they're students, they're young lawyers, they're people in a firm, shocking as that may be, who maybe aren't happy and would like to be working elsewhere. Give a sense of from somebody who's been through, and sits now in a major company in a very exciting industry. What would you say to those people looking at, towards what you're doing and what Verizon's doing, and would love to get involved in that?
So I guess I have a few items of advice here for folks. First off, if you're in law school or you're thinking about going to law school, this may seem obvious, but get in the best law school you can and do as well as you can, because you're only going to increase your options if you do it. Law school is a trade school. I know that people think it's an academic wonderland, but at the end it's a trade school, and you have to learn your craft and endure 3 years of it, in my opinion, 1 year of which is unnecessary. After that, my advice would be to get the best practical experience you can. Sometimes that's in a big firm, sometimes that's in a little firm, but there's the honest-to-God truth from my perspective. You leave law school knowing how to do nothing. And you can think like a lawyer. That's a quote-unquote think like a lawyer. That's a good thing, but you have to know how to do things like a lawyer, and that's a different skill. So you need to learn practical skills. So I wouldn't cut that short. I wouldn't underestimate the importance of that. Beyond that, I think the next step is to take chances. Lawyers aren't good at that. They're not taught to take chances. They're taught essentially to avoid risk. They're not taught that the only way you get ahead in life is to take risk, and that's true personally, and that's true in business. That's true everywhere. So if you're not willing to take any risks, don't take risks. I don't want you working for me, and I don't want you work. I think that you can find a nice sinecure somewhere, and that's fine. But take some risks. I didn't know anything about telecommunications before I went off and started doing telecommunications. And I think the willingness to reach outside your comfort zone, the willingness to take on responsibilities you're not sure you know how to deal with, the willingness to engage and move beyond the comfortable is what gives you the opportunity to get a new and different job. And that's basically my advice. Work hard and take some risks and see what there is out there.
That's great. I think I can't top that. So I just want to thank Randy.
Thank you,
for
Howard.
being here. Thank you for joining us. I'm Howard Homonoff. This has been Media Reporter. Thank you very much. That would be wrong. That goes